I wanted to talk today a little bit about marriage-based green cards. So one of the nice things about the immigration laws are that if a citizen marries a non-citizen, they can apply for permanent residency, otherwise known as a green card, for their spouse. And there's a few ways you can do it. So if your non-citizen spouse is here in the United States and entered with inspection, meaning they had some sort of visa, or there are other types of ways you can enter with inspection. But if your spouse entered the country with inspection, you can file what's called adjustment of status and get a green card for your spouse. If your spouse is out of the United States and has not been able to make it to the United States, you can also apply for a green card through a process we sometimes call consular processing. You also have situations where the non-citizen spouse entered the country without inspection, so without a visa, without authorization. In that case, that spouse still qualifies for a green card, but there's more of a process you need to go through, and you need to be very careful in cases like that. So if you have married a citizen, or if you're a citizen that has married a non-citizen and want to apply for a green card, be very careful to determine if your spouse entered the country lawfully. If you did not enter the country with inspection, you can still apply for a green card, but you have to go through another process. Typically, you will need to file what's called an I-601A waiver, known as a provisional waiver or a hardship waiver. But in those in all those circumstances, so whether your spouse is here in the country, they entered on a lawful status, or your spouse is out of the country, or your spouse entered the country but without inspection, in all those cases you can still apply for a green card, but they're different scenarios. And my advice would be to talk to an attorney before you start any of those processes.